You see there the defendant raising his hand, seeming like he wanted to get the attention of the court. They're taking that break. So while they do that, let's bring in criminal defense attorney Diane Bass, who is joining us for some analysis. And you're out of Irvine, California, Diane. So I know that a Spencer hearing is not something that is in every state. Florida specifically has this type of sentence hearing that's held in front of a judge after the death penalty is imposed or recommended by a jury. Talk to me about what you do know of it and how is it different when we're comparing it to a state like California?
California does not have this kind of a hearing. I do think that it is an extraordinary idea for the court to be able to revisit the issue because a jury is essentially 12 strangers from the community. In this case, they returned their verdict of guilt within 1 hour, which is extraordinary. That is really enough time to take a vote and fill out the forms. So how much deliberation occurred during this deliberation, this jury back in the jury room is suspicious to me. And then they came back in 3 hours with their verdict of death, which again, you are taking someone's life. This is something that goes beyond reasonable doubt. This is something that you can't take back once this act is complete. So I think that it is an extraordinary thing that this court does these kind of hearings. And I think that hearing from a mitigation specialist, expert, is extremely important because we are humans and crime doesn't happen in a vacuum. People do things for a reason. And if, in fact, Mr. Soto did commit this crime, all of his life should be taken into consideration.
Yeah, and she laid it out for this judge. She said that she saw authentic empathy from this defendant and that was unique even for her. We're about to, when we go back into the courtroom, Diane, listen to this defendant speak to the judge. What do you think the judge is going to have the same impact? As a statement in front of the judge, you think it's going to have the same impact for them versus someone who's a mitigation specialist talking to a suspect?
You know, the thing I've heard over and over from judges is that the only thing that's going to change their mind at sentencing is what the defendant says. And I always coach my clients to speak from their heart and speak to the judge, look them in the eye and talk to them about how they feel about what is happening. And it does move judges. So I do think that if he is sincere and if he does speak from his heart, I think it could have a tremendous impact on the court.
That is important to point out, Diane. Stand by. We didn't hear from Jose Soto-Escalera during this trial. He chose not to testify. Let's listen to what he has to say to the judge.
To confer with Mr. Soto-Escalera, any further evidence from the defense?
Well, Judge, I did have some commentary to make and some argument to make. However,
right. But outside of argument?
No more. Well, Mr. Soto-Escalera wants to speak, Judge. I do believe.
Okay.
My client would like to address that.
Okay, he may make a statement either under oath or not under oath at his choosing, allocution or otherwise.
He's allocuting.
Okay, you may make a statement, Mr. Soto-Escalera, at this time. Go ahead.
Thank you, sir. What I'm bringing to the courts to address is I have a conflict of interest with Thomas Burns. So I was asking for your permission, if possible, if I can get him removed from my case because I don't trust him.
Mr. Soto-Escalera, trying to think of how to say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at about 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already done his job. They've already completed their work on the case, really. At this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function, where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto-Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge, and that
the horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical?
correct. And as I explained to my client, I am not qualified to be on the case by myself because I'm only second chair qualified. So Mr. Worth has to remain on the case to the duration.
Right, and just for the record, I haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest. And does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto-Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel.
All right, we have to hit the pause button because we have to hit a break. But it seems like Jose Soto-Escalera wants to talk to the judge about issues with counsel instead of this empathy that the mitigation specialist said that he had to offer. Let's see if he has more to say, but we have to hit our break. More of the Spencer hearing when we come back.
Thank you.
Welcome back to Court TV Live. I'm Julia Janae. Thank you for following along with us, where we are in Florida for a last-ditch effort type hearing called a Spencer hearing in the state, where convicted killer Jose Soto-Escalera is making a final effort to get his death sentence recommendation changed by a judge. Now, he was convicted by a jury for murdering his pregnant mistress because he didn't want his wife to find out about her, and the jury found 8-4 that he should be recommended for the death penalty. And in Florida, that's enough to get a conviction and capital punishment. But the Spencer hearing gives the defendants a last chance to present any additional evidence that could possibly alter that sentence. Let's go back into the courtroom now. Picking it up where we left off, the judge gave this defendant an opportunity to make a statement. He first used that time to complain about the counsel that he has, the attorney that he says has a conflict of interest. But the judge said it's a little late for that. We're here at the final hour. Do you have anything to say?
I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about so you can understand what I'm trying to say, if you have the time, Your Honor.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And as I'm required to do, I would defer to their professional decision in that regard.
Enough, Judge. I'm going to lay it all out on the record, okay? I think Mr. Soto-Escalera is hurting his situation. He's proceeding in ignorance on the advice of ignorant people. What he is referring to is a Zoom-recorded deposition, the first such deposition I ever did in my life, with witness Lucinda Cook. This was done, I think, on a Tuesday when there was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before Ms. Cook joined, there was a recording with chit-chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits and chit-chatting as counsel do between themselves, waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in a case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto-Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bullcrap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot. On this issue, at least.
In that regard, for Mr. Soto-Escalera's benefit, the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly and then indirect appeals which relate to assistance of counsel, whether the defendant received proper assistance of counsel. That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in. Mitigation has been placed before me. So we're at that stage where I'm to consider that. Put differently, if Mr. Soto-Escalera feels that Mr. Burns did not properly litigate his case for whatever reason, will be a proceeding in that regard. But to be fair to Mr. Burns' respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court. In fact, we foster the opposite as professionals, that they get along, because once this case is over, they'll be on to a next case, and so will I. And so as professionals, they have to work with each other. But more importantly, as I mentioned at the outset, that is for another day. I'm directly focused on the extremely consequential and important decision I have to make, which goes back to whether Mr. Soto-Escalera wants to make a statement regarding himself, the case, for me to consider. He does not have to, and it's not going to affect him negatively if he doesn't, but he has that right to do that. So there again, we broached a different subject. I don't want him to think that I'm not going to listen to that, should he wish to listen to make that statement. On the other hand, I'm not sure he has an intent to do that anyway. He just wanted to broach this subject.
Correct, Judge. I think he said his piece and he has nothing
Okay.
to say at this
All
time.
right. So it's not the first time I've had to tell the defendant or someone else, that's for another day. There is a right to have a motion for post-conviction relief with regard to your Sixth Amendment right to counsel. That's for another day, really, regardless of my decision here. So other than that, that concludes the Spencer hearing evidence from the defense. Any evidence from the state before argument?
No evidence, sir.
All right, so let's start off with the argument of the state, if you wish to make a summary argument. But you don't have to. I mean, obviously, I'm familiar with my role here. I want to dissuade you from that, but you do both have the right to make argument to influence me in the way I evaluate the evidence,
Sure.
the way the aggravation and mitigation.
Yes, sir.
All right, now that the defense is done and things are passing to the state, let's bring back in criminal defense attorney Diane Bass. I've got to get your reaction, Diane, because I'm still stunned at this mini blow up that just happened between a client and a defense. Let's start here, because we were all leaning in. You mentioned the judges want to hear remorse. The mitigation specialist said he had empathy. He had this moment at this Spencer hearing to try and get his death sentence changed to life, and it fell flat.
It most certainly did. And in fact, it was quite explosive. My face, you should have seen my face when his attorney called him an idiot. I understand that he worked his heart and soul into this case and that he was extremely upset by these allegations and that it was silly, but he had to have bit his tongue. You don't call your client an idiot, especially in this moment. I mean, that was just, I feel for the attorney because I understand how he was feeling in that moment, but at the same time, oh my goodness. But as far as Mr. Soto-Escalera not making a statement, I think that was a huge mistake because I think, first of all, his lawyers should have advised him that he absolutely must make a statement. Allocution is critical, especially when your life is at stake. But I also sympathize with Mr. Soto-Escalera that he was afraid that if he admitted anything, then he would ruin his chances at appeal or at a new trial. So I think that still, Mr. Soto-Escalera should have said how badly he felt about the death of these individuals, about this woman and her baby. Even if he didn't admit that he had anything to do with it, he could have expressed sympathy, as you said. It was a moment that was just lost.
Frittered away, as they say. Diane, thanks so much for the analysis on this one. It could even be that his attorney thought he was going to do an allocution because that's what she mentioned right before he started talking. We'll have more of this Spencer hearing happening out in Florida for Jose Soto-Escalera next.